If you are facing a DWI, there are some important things you need to know about how DWI law works in Texas. First, let's talk about driver's license suspension. In a DWI case, there are two times when your driver's license can get suspended in connection to the DWI. One at the beginning of the case and one towards the end of the case or at the end of the case. So first, let's talk about the suspension that happens at the beginning of the case because that's the one, if you just got arrested for DWI, that is, the clock is ticking on that right now. So that suspension can either be 3 months or 6 months, depending on whether or not you consent to giving a sample of your breath or blood to the police or you refuse. If you consent, meaning you agree and you do it voluntarily, you don't make them go get a warrant, then that suspension is going to be shorter and it's only going to be 3 months. If you refuse, then the suspension is going to be longer and it's going to be 6 months. The other thing that changes based on whether you consented or refused is when the suspension goes into effect. If you consent, the suspension is not automatic. It waits until your blood alcohol concentration testing comes back, and the suspension only goes into effect if your blood alcohol level is a 0.08 or higher. If you have a lower blood alcohol level, then you don't get suspended at all. And so if you consented, the clock is not ticking, so to say, as much because you're waiting on those test results to come back, and those can sometimes take weeks or even months to come back. So in that case, if you consented, you want to be on the lookout for a letter that's going to be sent to the address that's on your driver's license, telling you whether or not your driver's license is being suspended, and if so, then the clock is ticking on when you can contest that. The other type is when you refuse. So if you refuse or if you're unable to consent, for instance, if you're too intoxicated, you pass out or you can't answer their questions, etc., and they mark you down as refusing, then the suspension is 6 months instead of 3, but also the suspension goes into effect immediately. So your suspension, your driver's license will be suspended once a 15-day window passes from the date of the offense. So you essentially have 15 days to challenge the suspension, and that is called an administrative license revocation hearing. So you or your lawyer can request this ALR, the administrative license revocation hearing, and that challenges the driver's license suspension. That can be done either if you consented or you refused, just the main difference is the timing. Once the ALR is requested, the driver's license suspension is put on hold until that hearing can occur. So here at the Law Office of Mike Howard, it's something we do for all our clients if they are wanting to be able to drive, is we go ahead and file that ALR because it gets them an unsuspended driver's license essentially for free. Whether the case against them is strong or weak kind of doesn't matter. So it's something we do for all our clients. Now, beyond that, one thing we recommend to all our clients, especially if they know they were drinking, is to go ahead and be proactive. One thing most people do not do when they're facing a DWI is take a proactive approach. And what I mean by that is go get an alcohol or substance abuse evaluation from a licensed chemical dependency counselor. We have licensed chemical dependency counselors that we work with all the time. We send our DWI and drug possession clients to them very frequently, and they will do the evaluation for us. What's nice about that is if you're going to get a DWI probation, that's going to be required of you anyways. So if you know that's coming, doing it up front, you can get credit for doing that early. But more importantly, if you get that evaluation and then they recommend follow-up treatment, you do that while the case is still, in its infancy. So sometimes before a case has even been filed, my clients, if they've been proactive and have followed my advice, have already gotten that evaluation, have already followed up with a substantial amount of treatment, and by the time they get to an actual court date, they have a very compelling reason why that prosecutor should cut them some slack. And sometimes I will get fantastic outcomes for clients because they did that. They get probation when they wouldn't have otherwise gotten probation. They get enhancements struck. They get deferred probation when otherwise that might not have been offered, etc. So it's something that you definitely want to consider doing. Beyond that, deferred probation is something that is very restricted for DWI cases, and so you are only eligible for deferred probation if it's your first DWI. You can't have any previous DWIs. You can't have any previous anything. Secondly, you can't have a a 0.15 blood alcohol concentration or higher. So your blood alcohol has to be on the lower side of things, and there can't be an accident involving injury involved in your DWI. So if you meet those criteria, then you can get deferred adjudication probation, which is great because that means it's not a conviction. They defer the finding of guilt and you're never convicted of the case. And at the end of the case, if you successfully complete probation, the case is dismissed. What's also nice about deferred adjudication probation is because they don't find you guilty, you avoid the dreaded super fine. And the DWI, the Texas Department of Public Safety, assesses a very heavy super fine upon conviction. And that is a $3,000 fine for first time, a $5,000 if it's your second time, and it just goes up. So deferred probation is a great way to avoid that super fine. So these are things that everyone should be considering in a DWI case and things that a knowledgeable DWI lawyer should be able to walk you through to help get you the best possible outcome.